All right, looks like we're at time, so let's go ahead and get started. My name is Chen, and I'm with NAC, the Consultants Training Institute, excuse me. Before we get started with the May 19th edition of Around the Valuation World, I want to go over a few housekeeping items. Um, First, to obtain CB credit, you must answer all the poll questions that pop up on your screen during today's webcast. If you have an AVW subscription with us, your CP certificates will be available through the NACB.com portal within 7 to 10 business days. If you don't have a subscription, feel free to click on that subscribe link and we can help you with that. With AVW, we try to cover all the hot topics in the industry. With the 2-hour window each month, a lot of times we can't cover all the information. So there are links in your materials on that page that you can click on to obtain more information about some of the other hot topics in the industry. And then if you have questions during today's webcast, please use the Q&A feature as those will be directed to the presenter. If you have any technical questions or questions for NACBA, please use the chat feature as also be directed to me. And with that, I'm going to turn this time over to Mel and Alina, who will get us started for today.
Thank you, Chinda. So good to be here. Welcome to the May program. We've got another good program. These are the correspondents that work with us, but our lineup today is we'll start off with one of the program favorites, which is Michael Gregory giving us industry headlines and highlights and deeper dive links for us to go through that. And then James Ewart will jump in with Michele Laws and Gregory Reagan to talk about the Narcissists, I can't even say it, playbook on financial games, which is going to be an interesting one. And then we'll bring Michael Gregory back with an old friend of mine, Roger Grabowski, to talk about perspectives from the bench and the lawyer's business valuation handbook. And then we'll finish up with Cheryl Hyder interviewing the judges, which is always a favorite, talking about AI in the courtroom, and Janae, Castell and Pat Rafanelli talking about some developments in standards and ethics. And we'll finish up with Stephen White interviewing Adam Sher about transfer pricing reports in your practice, another possibility for income streams. So with that, let's go to our first segment, which is with Michael Gregory. Michael Gregory is a qualified mediator, and in the Minnesota Supreme Court, he has written extensively on mediation, on valuation. He is a thought leader in the space and is always a wealth of knowledge. So, Mike, it's so good to have you here. Thank you, my friend, for being here, and I look forward to your session.
Thank you, Mel. You're too kind. I'm just always having fun. So here are some articles we're going to share here today. I just have to advance my screen. It has apparently frozen up. Let me just see. There we go. Here are the first three articles. Experts mitigating uncertainty by identifying fears relating to your clients and apprehension by your clients. Estate planning and buy-sell agreements after the Connolly decision. What makes effective marketing effective? Can witnesses talk about the case after the trial? Some comments here from an attorney that I think you're going to find helpful. You want the valuation experts to reconcile. What happens when your side and the other side thinks that they should find a way to resolve this? And then Musk's woes spotlight the value damage to corporate image. So we're going to talk about applying strategies to address client apprehension, recognize when clients don't follow the buy-sell agreement and the ramifications, apply effective marketing, consider keeping your mouth shut after the case, acquire skills to help the client reconcile, and recognize how to value damages to corporate image. And we're looking at via Musk's example. So the first one, mitigating uncertainties by identifying fears. You know, when you're working with clients, sometimes they have a lot of apprehension. A lot is at stake. This is in a very emotional time, and clients can feel isolated and overwhelmed, especially when addressing financial decisions, and they might not know where to go or what to do. And that's when you want to be calm and confident and competent with what you're doing. Yes, you know your technical rigor and how to do that, but clear communication and focusing on collaboration with them and explaining it in words that they can understand, they feel comfortable with, and they feel more comfortable because of your calmness, coolness, and that you know what you're doing. Focus on the things that the client can control. There are things you cannot control. You don't control the judge. You don't control the other side. But on your side, what are things we do and can control? And let's focus on those. And look at what's involved in the long term. I recently was involved in a case, I was involved in a course on mediation, and there were a lot of family mediators there. And they were talking how oftentimes the two sides in a divorce might say, we're going to focus on the children. But the mediators were commenting, that's what they'll say at the beginning, but in reality, they tend to lose focus on that. And that's something you have to remind them about. We're focusing on the children rather than my own self-interest and what is best for the children. And then estate planning and buy-sell agreements after the Conlin decision. This is that Supreme Court decision that came out, $3 million at stake. Is the insurance part of the estate or not? And the Supreme Court decided it was. There have been a number of articles with saying the Supreme Court got it wrong, et cetera. But when there's a 9-0 decision with what was left with the decision, that's a pretty strong decision. And with that, the Supreme Court, when you look at the commentary, and this commentary by this author, Brent McDade, he's basically saying he stands back and looks at it and says they didn't follow their own procedures. So everything was set up, but with what they did, they didn't do what they said they were going to do. So it left the court with really no alternative because they didn't do what they were supposed to do. So it's very important that the client follow through with whatever you have in the buy-sell agreement. And then what makes effective marketing effective by Rod Burkhart? Well, some lessons learned. Marketing is a continuous effort. It's a lot of work. It's never done. It's never one thing, but you'll try different things. And according to his article, and I agree with this, you try things, and when things work, you need to be consistent and persistent and do that over the long run. So he talks about measuring, recalibrating, and then measure again. And when he runs through the tactics, he puts number one as being speaking and writing. And some of these things can be relatively simple, both in terms of speaking and writing. So for writing, we've got Quick Read, for example, where you can offer an article there. And how would you react to the message that you are sending? How would you react to that message? And keep that in mind in terms of the recipient, if you were the recipient. And try techniques and keep what works, and again, discard what doesn't work. I know from my own experience, I've tried a whole host of different things with ads and journals and put them in CPA, state publications and things. And those didn't work out very well for me. But speaking and writing for me, for example, have. And then he says, measure your results with what comes of those. And then in his article, the author makes 9 metrics to consider. So 9 different things you can consider from your own marketing perspective. And then, can experts talk about the case? It's written by an attorney here. I'm not going to pronounce that name because I'm afraid I will murder it. But this individual, she wrote a great article. She says you have to balance disclosure with confidentiality. So what can you disclose versus what you can't talk about? And there are 2 major rules. Rule 702 focuses on the methodology and process, and Rule 26 talks about your report. You have ethical obligations that you set. If you're a CVA or you're an ASA or an ABV or a CPA, you have ethical obligations of what you can and cannot do in terms of confidentiality. And that includes pre and post trial. Your report, for example, may be part of public record. If it's part of the public record, yes, you can talk about that because it's part of the public record, but you can never discuss confidential information. And basically, when in doubt, she said, just seal it. Don't talk about what you want to say if you have any doubt that it's confidential and you can't talk about it. So you want the valuation experts to reconcile. And Carter and Pierce came out with this article, and they're commenting, there are times when your client, they've hired you as an expert, you've come up with your number, but there's actually saying, we think we should be able to reconcile this. So how can we reconcile this? And they bring up a number of different questions. Do you meet or not meet? Do we virtual? Do we do it in person? What are the differences? How important are the differences? What makes sense? And they offer a very simple example is presented in their write-up. But basically they're saying, consider what the most significant variables are and what kind of impact it may have to make a small change in something can make a big change in the valuation. So what goes into your assumptions? You're usually pretty good at reading someone else's report and finding out what the weaknesses are of the other party, but make the effort. But then pause on your own. What are assumptions that you made that maybe there's some room with respect to what you made on your assumptions? And then consider strategies and available alternatives. So for example, there are times when there are 6 major issues and one party may come in and say, I'm going to concede 4 of these 6 issues. Well, it only amounted to 20% of the value, but psychologically making the change on 4 out of the 6 variables, it's can be considered to be a significant psychological change. And look at expectations and how are you going to structure the meeting? Who's going to sit where? Who's going to say what when? How are you going to approach this? And then work with your counsel to put together what your strategy is going to be, practice that strategy, and then go into the meeting with the other party to try and reconcile the differences. Musk woes spotlight value damage to corporate image. Well, Elon Musk, I would say through January, was probably doing really well. And Tesla and how we look at his space program that he has and a number of different things. But starting in January with Donald Trump, a number of things have happened. A few mistakes were made. He commented, we make mistakes and we just change with those as we go. Well, it's had a very negative impact on Tesla's stock, as you're well aware of if you're following the news. So this article says, looking at scandals, bad decisions, other mishaps, etc., these have damaged the company's reputation. So this author, Hugo Martinez, he's with the European Association of Certified Valuation Analysts. He wrote an article and he says, as you take a look at this, take a look at both direct and indirect consequences of reputational harm. And he runs through a methodology of how you can try and analyze what the direct and indirect impacts are of the harm that Elon Musk has done to the image of Tesla. And he said there may be immediate direct impacts, and that's seen, for example, with the value of the stock, an indirect impact on number of sales, and then there are lost profits that can be through other means than just the direct things that you take a look at. So interesting article there. So we look at the sources here for today. Experts mitigating uncertainty by identifying fears, estate planning and buy-sell agreements after the Connolly decision, what makes effective marketing effective, can expert witnesses talk about the case after trial, you want the valuation experts to reconcile, and here's Musk's woes spotlight value damages to corporate images. So those are the different articles we talked about here in today's session. You can look at those in more detail. Each month, these are the different sources that I'm looking at with our section, with this particular session. And this week it was BB Wire, the EACVA, Forensic Expert Witness, Quick Read, and Willamette Perspectives. And I would comment, my source that I had back there in Willamette Perspectives, if you click on that, they had 3 really good articles. I only have time to do so much, so I shared one with you, but they had 3 excellent articles in the quarterly Willamette Perspectives this time. And that's my contact information each month. You can get in contact with me. If I can be of help to you, just let me know. And with that, I'll pass it back to either Elena or Mel. Thank you.
It's me, Mike. Thank you. Great having you as always. And especially when we are starting our show with all your positivity. So it's great. And for everyone, we have our polling question right in front of you. And so, all right, you all get ready because the next session is very interesting. I think it's one of the trendiest topics around because we're going to be talking about narcissists and money. And we are going to have our correspondent, James Ewart. He's going to be interviewing Michele Laws and Gregory Reagan, and they're going to be talking about exploring the narcissist playbook of financial games from a forensic expert's perspective. So, James, great having you today.
Thank you, Elena. And our presenters today for this segment are Michele Laws and Greg Reagan. And Michele Laws is president of Turning Point Financial Group and Divorce Dollars and Cents Corporation. She has over 20 years of experience helping individuals make sense of financial change in their life, and specializes in helping those who have experienced turning points in their lives, such as widows and divorcees. Michele is an investment advisor representative offering advisory services through Town Square Capital, LLC, and SEC registered investment advisor. Greg Reagan is the managing director of Reagan FVL LLC of Charlotte, North Carolina. It's a forensic accounting firm providing services throughout the Southeast and in other states. And he's retained by law firms across the country as an expert witness in divorce and commercial litigation matters. Greg's experience includes accounting and tax services, forensic accounting, business valuations, damage determinations, and fraud investigations. I've often said that those of us who practice in family law setting, should have a degree in either psychiatry or psychology. And Michele and Greg will discuss the intricate financial maneuvers often used by narcissistic individuals and their deceptive tactics and manipulative financial gains. Michael and Michele and Greg, welcome to AVW. And my first question is, why did you prepare a presentation on dealing with narcissists in divorce matters?
Go
I
ahead,
feel
Michele.
that I always feel that narcissistic abuse is one of the most overlooked issues in the industry, especially in divorce and other fraud investigations. So this is just a topic we wanted to bring to light just to educate and inform. Not that Greg and I are psychologists or we're in the mental health field by any means, but we deal with it, like you said, so much that we feel like these tactics, they're red flags, and just really learning what types they are is really important for us as professionals to know just exactly what they do in these type of engagements.
People used to ask me what is the greatest skill set that I use in my work. I said, without a doubt, it's the degree in psychology I failed to obtain. So when you start dealing with narcissists, and it seems like they're everywhere. It's very rare that we get involved in really tough, high dollar, complex litigation that one of the parties involved is a narcissist. So I guess my reason for holding this today and sharing all this information is that when you're serving as an expert witness in some form of litigation, whether it's valuation or some forensic analysis or even a damages determination, it's not normal. You encounter really difficult challenges, and we wanted to share some of that with everyone in the profession to help you be better prepared, because the first time you face it, it can be pretty difficult.
Yeah, well, we appreciate you being here. And so what, from y'all's perspective, what is a narcissist?
The first thing that comes to mind when I think of a narcissist is going to be manipulation. It's going to be control. It's going to be they're an individual with absolutely no empathy for others. They're just not built that way. But the scary part is they blend in just like the rest of us. So sometimes they're really hard to tell them apart unless you know the key traits and the characteristics that they're built up within.
When a person is in a relationship with a narcissist, for all practical purposes, that person doesn't exist in the narcissist's mind. In his world, it's all about him. He's the victim, or he's the king. In this case, you see the person putting the crown on. And it's difficult for that person who's in it. I think Michele and I both have been in relationships like that. And the real difficult part for the person in the relationship is people who are not in relationship with a narcissist. They think they're great people, and they don't really understand why the person in the relationship is having such a hard time.
So what are some of their common traits? And I know that both of you are coming from being there, and also then applying, I guess, what you've learned there into your practices at this point. So what key traits are you noticing with these types of individuals?
I think the overall arching one is going to be whenever you're engaged in these kind of matters, if you find that someone is being difficult, not that it means that they're a narcissist, but that should be a red flag to you of immediately they're not trying to cooperate. They're not disclosing all the documents that they need to disclose. They're trying to control the story and manipulate any part of the process. That should make us look forward and see what other types of things are going on, maybe coming from either the wife or the husband, whichever the case might be, that's our client, and getting an idea and getting to learn their personality so that we know what our battle is going to be going upwards and as the engagement progresses. And we'll kind of be able to be proactive rather than reactive. But ultimately, it's going to be controlling and manipulate everything.
There's a lot of false accusations that are made, a lot of, in many cases, narcissists that have access to a lot of money, they'll hire really good, smart attorneys and the attorneys will actually assist them in their narcissistic behaviors in not disclosing documents that are really necessary and needed, using the court system to facilitate the objectives of the narcissist, and it can become very difficult. Michele, you might want to go over this, that, in our experience, there's two types of narcissists. There's the really overt ones and the covert ones.
And I would say the overt ones, I believe, are the ones we probably encounter the most often in our day-to-day lives. These are going to be the very loud, obnoxious individuals that we may not let us get a word in edgewise. They're not going to care to speak to us about our particular situation or our life stories. They're going to care more about themselves. The one that we likely overlook, that would typically be that covert narcissist. That's going to be your quiet type. That's going to be in our cases where they're the victim, that they are the ones that oh, poor me, this all happened to me, look what my spouse did, but it's all a means of projection. So they actually drive their power very quietly versus the overt's going to drive their power very loud. But again, this is day-to-day life, and in cases we encounter, the one that's most dangerous for us is going to be the malignant type. And this is the one that's going to tend to control more of the situation in the story. These are the ones that are going to be more extreme than we even give them credit for. These are the type, by the way, that are going to threaten us as financial professionals and maybe the other attorney. This is your typical, think of like the old the bully, the playground bully or the con artist. That's these guys. And they are the ones who are going to blend in very much like a chameleon and be very hard to detect until you really dig in and understand a lot of their red flags and a lot of their traits that they bring into the engagements.
Well, we've got a question here from outside, and let's see if we can cover it right quick, because this really does cover part of what you're talking about now. What differentiates a narcissist in a divorce setting, for example, from an individual who is at their worst, considering the situation and the need for control is an attempt to grasp for control more so than a fundamental behavior issue? That is, rather than, how can we distinguish between a narcissistic person and one who's just really just trying to gain some control of their life and some control of the actual litigation that's going on?
I think that's a super question. I think a lot of people, they're always at your worst when you're going through divorce.
Yep.
But getting to know the clients and really talking to the other spouse about how were things in your household prior to the breakdown of the marriage? How were things in your life? How did things interact with the kids, the financials? How did things interact with the business, whatever the case might be? And you're going to be able to parallel some of those behaviors. And some of them, again, the spouse is going to know how they are. And then other times you're going to see other methodical behaviors and other types of processes that are just going to be very damaging with the intent. You're going to see delays intentionally to try to run the spouse out of money. So there's going to be other things that are going to come up over and beyond someone that's just going to try to grasp what's going on and just really be out of sorts.
One of the things I think I've noticed the most in divorce matters where you're representing the non-business owner spouse, and in this case, a woman, a female, we're all wired differently. And a narcissist in his behavior will basically want to crush and destroy this person that previously they supposedly loved. The tactics go far beyond just trying to get yourself through it and manage and have some control over your life. It's a win at all cost. And I have been in cases where one party would be willing to spend literally hundreds of thousands of dollars, in some cases millions of dollars, just to win, just to destroy the other person and leave them with really nothing. And then that person, the non-business owner spouse, very shortly they run out of money. And as the expert, you have to decide whether you quit because you're afraid you're not going to get paid, or whether you try to help them and help provide something in the court system. So for us as experts, when we're working with the non-business owner and we're dealing with a narcissist, it gets really hard.
Yeah, there's no question about that. And one of the things from a practical standpoint that we have done when dealing with that is that we make sure that we are communicating with the attorneys and making sure that they're getting us fees through the court system. So what do we need to be aware of then when dealing with a narcissist?
I think the image that we have in our slide is really meaningful because you're standing literally on razor blades, and that if you don't manage yourself properly, you can get hurt.
Yeah, you're going to get trapped. I think professionally, even, and I see a comment coming in about an engagement someone had last week.
Yeah.
We have to really know in the very beginning, who are we dealing with? We have to have very clear engagement letters, very clear scope, get possibly a larger retainer in the beginning, knowing that we may have issues in the background getting paid as time goes along. We want to make sure we set good expectations for the attorney and the client that we're engaging with of what could happen, realizing with our experience of, if someone's engaging immediately in this issue and there's a couple of businesses and they're in control of all the financials, we might have a very long, expensive process and just have that discussion early on.
Yes.
So we can't say enough about that. Sorry, Greg, go ahead, please.
Yeah, I was just going to say the typical things we run into is not getting the financial information we need. You have more and more email, more and more phone calls with the attorneys. You wind up devoting a lot of time that really has nothing to do with accomplishing the task at hand because you're trying to manage the project. There's a lot of misrepresentation. We've had financial documents that have been sworn to be accurate. They've been manipulated. They're not. They'll export something out of QuickBooks, say, into Excel. They'll manipulate the Excel, print it and give it to you and tell you that it's, proper information when they've taken certain information out of it. So there's a lot of things. They'll use family members, setting up trusts. There's just, I guess we could talk for a long time about some of the things that we have dealt with. Some of the things that you may deal with as an expert is, I mentioned retaining legal counsel that might actually assist them in their narcissistic behaviors, filing excessive motions that just frustrate the system, prolong the whole process, prevent discovery, hiding assets. A couple of the examples I think we were going to talk about in business litigation is, we've seen people take a simple business structure and then re-domicile the business entities in Delaware where you can't determine who owns the company. They'll bifurcate LLC ownership's interest and sell the equity interest and tell the court, I don't own this company anymore. All the while, the way the LLC documents are constructed, they have control over that equity interest. We've seen people set up trust and do hypothetical or theoretically estate planning, but they're doing it after the fact, after a liability has been incurred or at least threatened. And they'll transfer assets into these trusts. They'll set up family members to be the managers or the self-settlers of the trust. And they're just maintaining control over it all. But they bring a pretense into the court system that they don't own the asset anymore. So those can be pretty tough situations to deal with. Any advice, Michele?
I would say that sums it up pretty well. One thing to add, mentioning the attorney, is they're going to likely hire an attorney like them with the intent to intimidate the opposing counsel and the spouse because they want to break them down. They want to control that story and get to that end of the settlement. And all the issues we just discussed, they don't want any of that to be found out because when that happens, they're going to be challenged, they're going to ramp up, and then they're going to do something else. They want to keep it all under wraps and pretend none of that exists. And their attorney can actually help enable that.
So if you're dealing with this, you want to learn more about it, some of the books that Michele and I have read that we found useful, we've listed here. You can certainly get that. But just hopefully what we've shared, 15 minutes is a very short period of time. Michele and I think spent an hour delivering this information at the last NACVA conference. So there's a lot of information, that we could share, but in 15 minutes, hopefully we've given you an overview to where at least you know how to dig a little deeper.
Well, this has been incredibly helpful, and I think many of us who have who deal in this area come across this all the time, and I'm sure we all, I mean, I just come to mind several people that I've dealt with that meet this behavioral aspect, both that I've represented and also that I was their retained expert, and then certainly on the other side as well. And yeah, I find them very difficult to deal with. And I've got some traits, I think, that would kind of bounce up against their traits. So having them as clients, I find challenging, because I find them very hard to. They don't listen.
Right. It's a different issue when you are retained by counsel for the narcissist. It's a different set of rules. You still have some of the same difficulties getting information, but they can be extremely hard to satisfy. They'll be critical of you if you're not doing exactly what they want you to do. They're expecting you to be their hired gun. And, you know, as a good expert witness, we're not supposed to be a hired gun. We're supposed to be objective, unbiased experts whose duty is to bring testimony into the court to help the court understand the evidence and make appropriate decisions. The narcissist doesn't want that. They want you to be his hard gun. And so it can be pretty challenging for you when you're retained by counsel for the narcissist.
Well, thank you all very much for being here today. This has been very helpful and enlightening, and hopefully we're going to hear more from y'all in on this topic, and maybe in some formal training, because I think it's something that we as a profession need, that kind of help and cooperation among each other, so that we can learn from each other and develop how a skill set to deal with these issues. So thank you again for being here today. We'll turn it back to you, Elena.
Thank you for having us.
All right, thanks, James. Thanks, Greg and Michele. Really quick, I just posted the second poll question. Before we proceed with the next segment, just want to share a screen real quick. So Greg and Michele, they presented this topic at our last conference in Las Vegas last December. We do have our upcoming conference coming up in September. It'll be September 11th to 12th. It'll be in Salt Lake City this year. There is a QR code that's on the screen. You can click on that, or you can go to nacu.com/conferences for more information about that for our next conference. So hope to see you all there. Thanks again, James, Greg, and Michele. And with that, I'm going to turn the time back over to, I believe it's Mel this time.
Yes, it is. Yes, it is. Thank you, Chinda. I hope to see you all there. And we're going on to our next session, which is with our friend Michael Gregory and an old friend, Roger Grabowski. I haven't seen you in a while. So good to see you, my friend, and have you here. Thank you for sharing with us. And they're going to spend some time talking about the Lawyer's BV Handbook and really start to break down some of the value and the stuff in there. So I'm gonna let you go. Is Michael in the house?
I'm here.
All right. So I'm gonna turn it over to you, Michael. You can do a more formal introduction of Roger, and I'll let you take it away.
Okay, thank you. I brought it up when I hadn't shared my screen, but I'm bringing it back now. Thank you.
All good.
Okay. Well, Roger Grabowski, what a pleasure and an honor to have you with us here today. Roger Grabowski is an outstanding individual known throughout our profession. He's a managing director of valuation advisory services with Kroll. He has over 50 years of valuation advisory experience. If you've attended any NACFA, ASA, AICPA type conferences, he is a consummate speaker. He's gotten the Lifetime Achievement Award from the American Society of Appraisers. He's an American Society of Appraiser Fellow. He's extremely well published. He is the person on capitalization. He speaks on this topic often. He's got tremendous insight. In terms of background, he's from Loyola University of Chicago and attended a doctoral program at Northwestern University. He is in Chicago, Illinois today, and I have with me a copy of the book. Tough to see that on the screen, but I have a copy of the book. It's the third edition of Shannon Pratt's The Lawyer's Business Valuation Handbook. And this is a weighty book. And just as I look at the table of contents, and there's Roger showing you too, just to give you an idea, this is a 40-chapter book, 662 pages. This is put together for the American Bar Association Family Law section. If you take a look in terms of the indices, there's these 40 chapters, and then there's an 18-page just index of court cases that are cited and introduced to you. There's a 21-page index in the back of this book. And of these 40 chapters, Roger wrote 10 and co-authored 1, and he edited the entire thing. And having written 12 books and worked with different publishers, this thing, looking at 40 chapters and all the different authors, I can't, and I was an author of just one of the chapters, I can't imagine the work that Roger put in order to coordinate and herd cats and go through the many different iterations. I don't know how many iterations we went through, Roger, but we went through a lot of iterations. And Roger is the man that made this happen. So with that in mind, Roger, welcome, and tell us about the book.
Thank you, Mike. I'm very happy to be here. I'm pleased to introduce to our audience, for those that have not been seen the book, and recommend the Lawyer's BV Handbook. You know, the first issue that you have is, why did I do this? It goes back to my relationship with the late Shannon Pratt. Shannon and I did Cost of Capital, several editions of the Cost of Capital book. The last one was in the 5th edition. And as part of that, Shannon then asked me if I would, as he was having a harder time getting everything done, he asked me if I would help him with, first of all, the 6th edition of Valuing a Business, and what we looked at as a parallel book, the Lawyer's BV Handbook. Now, when you look at when we laid things out, we tried to see the content of Valuing a Business and the Lawyer's BV Handbook. Now, people ask, well, why is this book useful versus Valuing a Business? Two different audiences. Valuing a Business is for the practitioner who's doing valuations, who's being introduced to doing a valuation for the first time. So it's technical from the valuer's standpoint. This book is designed to help you as a valuer explain what we do to the attorneys. I'll give you an example. And this is what just happened within the last, less than 6 months. I'm involved as an expert or as a consulting expert in a family dispute. The client who runs the business asked me to help him interview litigators so that he would have someone on the phone. I gave him a list of potential litigators, and we interviewed, and it's rare that we get to actually help a client by interviewing the litigator. Usually the litigators are interviewing us. So we picked a litigator, and the procedure that was initially worked up between the parties was to go to mediation. And the reason you go to mediation in a family dispute is you don't want open court is taking your kimono and opening it up to everybody. Okay. Mediation is a private matter, and oftentimes family members, sometimes they don't, but oftentimes family members would rather fight privately rather than in open court. So the question was, can we get in mediation a single appraiser? Well, they decided on one based on, we gave them a list of different people to contact and qualifications. And then the attorneys had to agree on what they wanted the appraisers to do. Well, I have seen over the years many agreements poorly written by lawyers because they don't understand terminology that we live with every day. So I pointed out material that was in the lawyer's BV handbook so that they could, in fact, agree on what were the lawyers, what was the appraiser to do, what were the definitions that they were to use, what was the, I use this book real time with very experienced litigators. Remember, most litigators don't do valuations every day. They do all kinds of litigations. So bringing them back into the valuation world falls on on us. This book is designed to help you help lawyers understand what we do. That's why I thought, even though I was involved in doing valuing a business, I was the lead on that. That's a different target audience. This is an audience. This is by the way, the American Bar Association, there was nothing else that they had that was like this book. And that is to go through what are the concepts that we use, how to explain it. Each chapter, for example, has a list of what this chapter you will learn about, bullet, 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 bullet. And so even though it has a title, it helps the lawyer know, is this the chapter I really want to look at? Look at the attorneys for your clients. Oftentimes, they've done all kinds of legal work for a client. And all of a sudden, a litigation starts. They need something, the lawyer needs a resource where they can go in before a meeting and sort of know what's going on. And we tried to expand this. This is the third edition. We expanded it beyond what was in the second edition so that there were topics that, not just the things that we deal with, like gifts, estates, etc., but also intellectual property disputes. In this day and age, a lot of clients need lawyers to help them protect their intellectual property. There's a particular important chapter that was added that isn't a parallel in VAB 6. We added this valuing interests in real property holding entities. Because oftentimes you have an operating business and a parallel real property company over here owning the real property that is being used by the operating business. And they may not have exactly the same ownership. How do you deal with that? The operating company may be an S corporation, the other entity may be a C corporation. The operating entity may be a C corporation, the real estate entity is a pass-through. How do you reconcile those differences? We wanted to bring that because that is from my experience, a real issue that happens more often. We have a chapter on fairness matters, solvency matters, and lost profit matters. It's important for the litigator to have sort of a someplace they can go to and look at this. Then we have a checklist for reviewing a business valuation report. And finally, Anita Ventrelli, a very good litigator, helped us with some chapters that are real specific to lawyers. What's admissible in the court by expert witness valuation evidence? How do you do discovery? And Mike was nice enough to author a chapter on penalties. Believe it or not, lawyers are completely unfamiliar with appraisal penalties. It's just not in their spectrum of knowledge of, everyday work. And so we have, and then Anita Ventrelli also helped us with examining a business valuation expert in depositions and at trials. So this is a go-to book for lawyers. Question: why am I recommending for the NACVA members? You need, I want people in our profession to stop thinking of themselves as appraisers. You get work and you get fee for being trusted business advisors. Appraisers are number crunchers. Business advisors talk turkey with the owners. You need to help your clients and their lawyers to understand what we do. That's why we put this book together.
Well, Roger, when you think about this and you think about us as valuers and the need to explain what we do to attorneys so that they understand what we do, what do you see as common problems that are typically take place that because you have this book, you can address those kind of situations?
I'm sorry, Mike, will you please repeat?
Sure. For us as business valuers, there are questions that folks are going to come up with. And what do you think this book in particular is able to address when those kind of questions come up? What are the kind of questions that you think will come up by an attorney that this book will help with specifically?
Well, what is the standard of value? Let's start there. Mm-hmm. Oftentimes, there's big confusion as to what is the correct standard of value when they're writing an agreement. They don't really understand the nuances of the terms fair market value. They don't understand, a lawyer gets together with two entrepreneurs who are starting a business. And the entrepreneurs don't have any agreements for the first 6 months because they didn't have time to even think about it. 6 or 8 months later, one of them says to the other, we've got something that's working as a business. We should talk to a lawyer, a business lawyer, about how we make sure we have the right documentation to protect this business. So there's twofold: protect the business from falling apart between the two owners, and protect the business from outside attack. So they start and they get together with the lawyers, and the lawyer doesn't know what to do with a buy-sell agreement. We have a chapter that introduces buy-sell agreements in here. He says that's the first thing that you have to do, because I've seen times when people handshake a business deal and later on they decide maybe we should get divorced. And I don't mean marital divorce, I mean business divorce. So let's prevent that. But you would be surprised how many people go into buy-sell agreements, and the buy-sell agreements are poorly written. And all of a sudden you have a dispute. So the questions of what are the correct standard of value that you intend to have in the buy-sell agreement is something we cover in here. And yes, there are resources that are in depth about buy-sell agreements, how to word this, etc. This is really designed to be an introduction so that that lawyer going into a meeting can quickly get up to speed and have information to be able to discuss with their clients. Now, why am I asking? This is an American Bar Association book. Why am I suggesting that people recommend this book to lawyers? It goes back to my premise. You want to be a trusted advisor. You want to be a trusted advisor to the lawyer. You want to be a trusted advisor to maybe those two entrepreneurs. This is a resource for them, written at a different level than valuing a business. This is designed at a higher level just for understanding the theory, the language, etc. Not necessarily how to do it. It is there so that the lawyer can go into the meeting with the two entrepreneurs and say, have you considered this? Have you considered this? Have you considered this? So that what we do to outsiders, and I'm going to use those two entrepreneurs as outsiders, what we do is Greek to them. It's foreign. This is hopefully a book that will help you, the members of NACFA, become a trusted advisor by recommending this.
I use it for exactly that purpose. I'll first comment that an attorney told me the time to plan for the divorce of the business is when you form the business. That's when you plan for the divorce. Hopefully you'll never have a divorce, but you plan for the divorce when you form your business. I'll also comment, I'm involved with a case right now. It's on the East Coast. I'm in Minnesota. And with my client, they have a very significant issue regarding the issue of fair market value and initially setting up a trust and then removing assets from that trust by a controlling party and replacing them with assets that are worth far less. And so the question is, what is equivalent value? And I can't comment about expertise on what is equivalent. I don't have anything in the tax code talks about what's equivalent. But I can talk about what is fair market value. And when you set up fair market value, and I'm not an attorney, but I can come back in and say, working at formerly for the IRS for 28 years, if you take assets out of there and they were brought in at fair market value, what you take out and put in, the experience I had is not to make the determination, but the attorney asked me, what's fair market value of these assets they're now putting in? And if they're coming in at 10 cents on the dollar, it's not going to cut it. But what I did for my client is I said, I want you to know it's not Mike Gregory talking here. I'm going to give you a book. That's what I did. I'm going to give you a book. They're in the East Coast. I'm in the Midwest. I'm going to say, this is the book you need right here. And then they have that as a reference. And then as I'm talking, it's not just Mike Gregory as their expert. It's, I have some authority. And since the book is also the American Bar Association as the founder of the text, that gives some real credibility with that attorney. And that then gives me credibility back with my client. So as you're talking about this, we just talked about estates and gifts and setting up. You have any comments you want to add? We've got maybe about 3 or 4 minutes left on mergers, acquisitions, or any other elements, intellectual property. Anything else you want to bring out specifically within the book here, Roger?
I do want to bring up the intellectual property. We do cover that. We do cover damages. We oftentimes, they don't know, the entrepreneur, their corporate lawyer doesn't deal with damages. That's not something that of the nature, and they need to understand what's going on, what are the approaches for damages, because they may have to go out and find a lawyer who's appropriate to help, again, being with their client, covering damages. And so we have a nice chapter that introduces the concept of damages, how they're measured, etc. It is not, again, for the practitioner who's measuring, but for the understanding of what's going on in the damages. Going back to Mike's example of, or a comment that the lawyers are sort of at a disadvantage because what we do is like foreign to many lawyers. They may have dealt with it back in law school very briefly. They don't remember, just like we don't. And the other part about it is, by the way, I see that Judge Platt is on the screen here, and he was nice enough to write a foreword for the book, recommending it. And I think all I want to do is in closing is that if you want to be viewed as more than an appraiser, you need to have a tool to help talk and help like Mike did. Here's a book to help you. I hope that you would consider this. Thank you.
Well, Roger, thank you very much. And I know we're going to talk in just a second. They're going to introduce your session you're presenting later on today, 4 to 5 Eastern time. And with that, I just want to say thank you very much for taking your time for being with me today and being on with this short segment, and look forward to your presentation in more detail this afternoon. Thank you so much, Roger.
My pleasure. Thank you, Mike.
Great. Thank you, Mike. Thank you, Roger, for doing that. Let me just share my screen real quick. As Mike and Roger mentioned, there is another webinar following this AVW webcast later today. So Roger Grabowski will go in depth for 1 hour, starting at 4 p.m. Eastern time on. If you are interested and haven't registered yet, there is a promo code at the bottom of the screen, AVW in depth 20, to receive 20% off registration. If you are interested in joining that, so that is later on today. You can just click on the register here link on that page. With the AVW in depth, if you're not aware, we try to elaborate on one of the topics each month into a longer segment, kind of elaborating on the same topic. So in June 23rd, we have if you want to practice business valuation, you have to peel the onion. That will be available in June. And so if you want more information about that, go to nacb.com/AVW in depth or use that QR code that is on the screen. And then I'm going to turn it over to Alina, who will talk about this AI prompt engineering course that's coming up. I believe it's next week, May 28th.
Thank you, Shanda. So as many of you know, we are having an artificial intelligence webinar series. We started with a free one 3-4 weeks ago. Then last week we had our introductory training. We talk about ChatGPT, Gemini, and we talk about ethics. And one of the questions that kept popping during that training was about AI prompt. How can I do AI prompts that are useful for doing business valuations, forensic work? So that's what we are going to talk about in May 28th. We are going to have Colin, and he's going to be talking about AI prompt engineering and how to get better results from AI for your consulting practice. So it's very specific. We usually have samples and information that you can use. So you can go to the QR code and you can subscribe to that one. But I also put on the chat the link that has all the series. So you can go there, look at the trainings, and look for those that are going to be useful for you. We have at NACBA, we have a commission that we are working on making sure that all our members learn about AI, they feel confident to use it, and that is productive for all of our practice. So go there and just subscribe in any of the trainings that you may think is going to be useful for you. And now we are going to go to the next session. And that next session, we're going to have Cheryl. She's going to be with us, and she's going to be interviewing our judges. So yeah, we are going to be talking about AI in the courtroom. So Cheryl, you can take it from here.
Great. Thank you so much. So first off, Judge Driscoll can't be here today. So we are lucky enough, though, to have Judge Yates and Judge Platt here with us. And, the big topic that we're all dealing with, we're all hearing about today is AI, right? It's all over the place. And the court decisions are starting to come in. In fact, there was one, I think, maybe 2 weeks ago, a 77-page opinion where a brief got bounced because of all of the bogus AI references to court cases that didn't exist. So with that, I thought it'd be a great topic to talk to the judges about this month. And I think what we're going to do is we're going to toss this first one to Judge Yates, because I think he's going to really want to talk about it the most.
That's true.
Judge Yates, the big issue is, as you know, we talked about this before, with all the changes to the federal rules lately, which impact us mostly, right? How is that affecting the practice of law? I mean, do we need more extensive guardrails to protect the integrity of the system, the process, et cetera? As professionals, do we need to do more than we currently are, or is this just another cog in the wheel of justice? What are we doing here?
Let me start by talking specifically about something that you mentioned in your materials, deep fakes. And I want to talk about the admission of evidence, because I think that's a particular concern in the era of AI. For a long, long time, the rule has been that a judge has to consider as a threshold matter whether there's any evidence to suggest that an exhibit is what its proponent says it is. Right. And there's a screening process that goes on before the evidence can be admitted. And all that has to do with establishing foundation. Now, foundation for an exhibit requires something called authentication. Authentication is a process by which the proponent of the exhibit shows by some type of evidence that the exhibit is what the proponent says it is. Let's say it's a picture of my house and I'm on the stand and somebody shows me a picture and they say, do you recognize this? Yes, I do. What is it? It's a picture of my house. That traditionally has been sufficient to establish foundation. And once that authentication process is complete, just through my testimony under Rule of Evidence 901, the exhibit then goes to the jury, and it's up to the jury to decide whether, in fact, that exhibit is authentic and how much weight to give it. Now, that was perfect in the days when exhibits were a shotgun or a picture or a map or something like that. But in the era of AI, as Cheryl, the materials you've provided show, there are lots of situations where it's easy to produce a deep fake. So you can have either a picture, still photo, or a video of, for example, a car crash. And it's completely generated by AI. It's not an accurate portrayal of what happened. And so it requires a fair bit of electronic sleuthing to find out whether it's authentic or not. Now, the rules don't contemplate that, but I think it's fair to say that judges are going to have to think a lot harder about how much to get involved at the threshold in deciding whether an exhibit can go to the jury.
But that brings us to the next point, Judge Platt, we know you're here too, so I'm going to throw the hard one at you. Sorry, Judge Yates. Does the court need...
If it's too hard, I'll throw it back at Judge Yates.
Perfect. That's perfect. Is it necessary, do you think, for attorneys who are offering this evidence or proffering it to provide some kind of affidavit? I know this stuff is authentic because, and then sign off on it. Somebody has to put their name to it. Do you think that's necessary at this point?
More than it was. I think it's fair to say, I know it's true in Maryland. I suspect it's true in Michigan and New York and everywhere else, that the judiciaries of both federal and state judiciaries are at work trying to figure out the answer to the questions you're asking Judge Yates and I. In the meantime, I think the byword is check your work, period. If you're an attorney and if you're an expert. Maryland has had a case, I think I mentioned it in another program, where a principal of a high school was videoed and produced in court, the video and him. It looked like him, it sounded like him, but it wasn't him. Wow. When you're to a little bit of follow up on what Judge Yates said, which is absolutely 100% what his point was, is that Judge Paul Grimm, who's a retired federal judge and who's pretty much of an authority on this and generally retired on evidence, was talking about this case and talking about this issue. And one of the judges that he was teaching looked up and said, "Excuse me, you are terrifying me."
Yeah.
But it's too easy. I just finished some cases involving climate change. I simply said to the attorneys, all of whom were California lawyers representing Maryland and other places, you need to certify that if you are using AI, that you are checking your work. There's no rule that says that one lawyer kind of hinted that he didn't know of any authority for me to do that. And my response was, well, I don't know of any authority that says I can't do it, and I just did.
There you go.
So that caution is necessary. I know judges who've commented, I knew this program was coming up, and I happened to talk to one who I knew had this experience. He received a brief from an effect supporting a motion that had chock full of cases and quotes from these cases. Neither the cases nor the quotes existed.
Right.
The opposition attorney said, had it been somebody he knew and respected, which tells you he didn't, he would have called him and said, you need to pull that back, you need to withdraw it, you need to explain why, and I'll give you leave to file, late
Right.
a true. And he said, I didn't do that. I just filed an opposition that basically said there's nothing in here that is true, accurate, or reflects reality, and so forth.
Yep.
That's the kind of, until we figure out what we're doing, and we as the judiciaries of this country and this state, check your work. An expert who is produced, whether it's a fake expert or somebody that says they're Cheryl Hyder and they're not, they need to keep an eye on what's going on. And anybody that's going to testify, let alone offer an opinion,
Right.
needs to check their work.
But it's not so much checking our work per se as it is making sure that
Sources,
we're working with good stuff.
right.
Yes?
And
Yeah.
there's now the question that used to not be. In other words, the assumption was, hey, Cheryl Hyder is Cheryl Hyder. Her opinion is her opinion. We don't quite have that same level of certainty now. Nagging
Right.
behind it is probably, but let's see if there's an issue at all.
Yeah, I
Cheryl,
mean,
can I draw an analogy here? Because I think
Sure.
what you're suggesting makes all the sense in the world. For a long time, courts had a regular process of admitting expert testimony, and it wasn't an especially rigorous test, and it was clear, and there was only one real point to it. That was the Fry test from
Right.
now over 100 years ago, and it had to do with general acceptance of the view being presented by the expert. Well, then eventually, when Rule of Evidence 702 came along, there were several factors that had to be satisfied in order to admit expert testimony. And then the whole concept of Daubert challenges grew up around that, and the rule's been amended and amended again. And so now trial judges are expected to conduct a much more exacting review of expert testimony before it goes to the jury. It used to be that we could just blithely say, well, I'm going to let the jury hear it, and I'll let the jury determine how much weight to give it. But that goes to weight and not admissibility. I would
Right,
say
but-
the same thing about Rule 901. Rule 901 of the Rules of Evidence deals with authentication and foundation for exhibits. Again, the practice from time immemorial was that we essentially allowed somebody to take the stand and say something is what the person says it is, and then it goes in front of the jury, and the jury determines how much weight to give it. And I think what you're suggesting is we may need a much more exacting pretrial process akin to the Daubert analysis or the Daubert
Right.
approach to figure out whether, in fact, these exhibits are authentic, which would require review of metadata and all sorts of tags on electronic evidence.
which,
And I would just add to that further that, as Judge Grimm pointed out in a program that I had a pleasure of attending, if you're a trial judge and you're sitting there and a witness is on the stand and the evidence is presented, a video of that person is presented, and his voice and her voice is heard, and his image is seen. And the only thing you have opposing the admission of that evidence, because that's the evidence, is the person who says that's not me and that's not my words. You're going to, and the burden is theoretically is preponderance of the evidence even on that issue, and you're going to let it in. And
But-
now, unless they say something more than just a simple denial, I don't understand how that happened, but it's not me.
so in other words, instead of authenticating my report, I'm now authenticating that video of me, which
If
is
that
then
is
going to
done,
turn
If-
into its
if-
own,
yes, if that is the situation.
right.
If
So-
nobody does that, you don't have to authenticate something that hasn't happened and it isn't happening. But if it becomes an issue, there are companies, and one of them was on our panel, who you can hire. They're expensive. And that's part of the problem.
That's
Okay?
one of the questions that was coming
Yeah.
up, that I was going to hit Judge Yates with this one, because, just to be mean to him. Is it something that we need to do at your level, where you and your staffs need to have a minimum level of competence to understand not just the terminology, like Roger was talking about a few minutes ago, so you folks understand the concepts behind what we do, but also now should you also have to understand the concepts behind AI and how these fakes are coming out? Do you
I'll
think
say
that's
this.
something that should fall on you? Or
I'll say this. Almost every bar association that licenses attorneys has added an ethical rule that requires all attorneys to maintain technical competence.
okay,
And we also have that in our court rules. Now, that's often not put to the test. And in addition to that, although judges are bound by that requirement, it's awfully difficult to say that you could disqualify a judge on that basis.
Right.
A wise judge who doesn't fully understand the technology, at least under our rules in Michigan, is allowed to retain at the party's cost an expert to advise the judge. That can be done, but of course that builds another layer of cost into it. In a perfect world, judges would be perfectly competent to judge the authenticity of exhibits based upon a presentation by both sides about why the exhibit is either authentic or a deep fake. But we don't live in that perfect world, and there are lots of judges, myself included, who wouldn't feel fully comfortable doing that analysis.
okay. So
And if you're electing judges, you can't unelect them because they don't know what they're doing.
Right.
Be nice if you could.
So what about the just to argue with myself, if you will, isn't it, would AI somehow just be considered another black box tool? Say, for example, when computers became more prevalent, right? It drove me crazy when I would hear younger staff say to me, well, that's what the computer said, so it has to be the answer. Okay. So,
Yeah.
I mean, how can we see the AI as something more than just that same black box?
Well, I suppose eventually almost everybody will necessarily have to have a much better understanding of how AI operates.
Mm-hmm.
But I would say that you don't fully have to understand how AI operates to understand, in most instances, whether electronic evidence is fabricated or whether it's authentic. That requires knowledge of some simpler concepts that, for example, most paralegals understand. I think that the way it works today is, and I haven't practiced in 17 years. I'm a judge, and now that I'm on the Court of Appeals, I get whatever's in the record, so I don't have to worry about this. But if I were a trial judge and I had to worry about it, I think it'd be a lot easier to discern the provenance of an exhibit just by a fairly simple review of the electronic version of the document itself. Now, this gets harder, and I recognize, for example, that metadata can be stripped from an electronic file. People can play games back and forth. But what I've discovered when I was running the business docket is that there are experts out there who clearly understand all of this. For example, there are hearings that I've run where documents were, for want of a better word, deleted by the maker of the documents because the maker didn't want to see what had been put in writing at some earlier point. Like, for example, all sorts of communications about stealing customers when they leave. I've learned that there are experts who can essentially pick up fragments from unallocated space and put those documents back together again. And I've seen people just turn ashen when those documents appear on the screen in the courtroom. Person thought they destroyed them.
You're talking about the remnants that they pull back together.
Right. Exactly.
Artifacts. I'm sorry, artifacts.
Yep. So as far as I can tell, it's not especially complicated to figure out the provenance of a document, to figure out whether it was legitimately created or whether it is a deep fake.
Well, Maryland used to have a rule, by the way, that was abolished because it was unfair. viewed as unfair. I'm old enough to remember when it was still there, where if you called a witness as a lawyer, you were vouching for that witness's credibility unless you, before you put him on the stand and had him sworn, asked that they be treated as a hostile witness. And now if you had that now, okay, then you would have a situation where you're vouching for, you better make sure that what you're vouching for is in fact that witness, expert or otherwise, and that he or she is telling voicing their opinion and not an opinion that AI came up with when they couldn't think of anything else. I don't know that you want to go back to that. There are the rules, as Judge, I'm sure Michigan has, Maryland has an analogous to the federal rule, where when you sign a pleading, you are in effect saying that you're not vouching for the credibility of the facts you're alleging, but you are saying that you're signing it and it's not for any illicit purpose and blah, blah, blah. That's borderline this issue. Somebody wants to make it this issue, they could. But, and I've had somebody raise with me the issue of, okay, you're going to have somebody check it. If it's not you, who's checking the checker?
Right.
And I mean, you can carry that to the extremes,
Right.
and you can spend all day trying to do that. But the courts are struggling with it, and the danger, like everything else, is that we won't have a uniform rule. We'll have to figure out what each of the 50 states is doing. You'll have to do that as an expert.
So, but the
But you're going to
question
be
is,
asked about more than you ever would before.
Well, but-
Did AI play a role? And if it did, what AI was it? Was it Chat GPT or whatever? And
Right.
how did you do it? And who was involved with you?
but here's the one of the concerns with that is, I read about a case last week where an expert used AI. They uploaded, speaking of confidential information, right? They uploaded their raw data, had one of the different platforms do the analysis for them. This goes back to my question about the black box. And that provided a subtle, very succinct analysis and a conclusion that they just dropped into their report. And they had one sentence. I think there was a sentence in the report somewhere that the analysis was assisted. But what does that even mean?
Yeah.
Sure.
I mean, so getting back to
if the court notices it means they're going to inquire further if they have any doubt, particularly if the opposing counsel or opposing expert makes an issue out of it.
All right. So rather than talking about the jury's expertise, so I think Judge Yates likes to punt the requirement to assign a weight to the AI potential to the jury. So
Yeah.
are we now going to have an environment where the jury needs to have that expertise?
I don't think so. And understand, it's not my preference to do that. That's how the rules of evidence deal with it today.
Right.
And unless we amend the rules of evidence, Rule 901 makes it pretty clear, and case law well establishes this proposition, that the jury is the ultimate determiner of the authenticity of the document and the weight it deserves. The question, I think, for courts, and particularly those who write the rules of evidence, is whether to advance that analysis into a much more fulsome discussion as a pretrial matter and put the onus on the trial court to make a threshold determination as the gatekeeper about whether it comes in. That's akin to Daubert analysis, except now for authenticity.
Okay, so it took how long to have the federal rules of evidence amended or updated? Like 10 years, was it? 5 years?
Well, Daubert came out in the 90s. So, I mean, I guess if I can do the arithmetic right, we're 32 years down the road from Daubert. And we're still trying to fine tune the Rule 702 to deal with how it's supposed to be applied.
Well, great. So we can tweak 702 at the same time as 901 gets a little bit of mending to address, the complications with AI then, right?
Yeah, I think that there's no reason you couldn't rewrite 901 to provide a gatekeeping obligation for the trial courts. The only thing about that is it'd be a sea change, but it may be one that's necessary.
Well, times change, right? All right,
Indeed.
Judge Platt, you get the final question. So these changes that we're talking about are going to be, they could potentially be expensive and they could potentially have that cost land on the litigants. So how is this going to impact the accessibility of justice for parties to litigation?
I'm in the business of private ADR, so I hope it impacts it that way.
Nice.
And actually, that presents other problems.
Right.
Because then you're in there and you're not in a courtroom, nobody's under oath, and you're talking and you have experts or you don't have, they're either there or more likely they're being quoted
Mhm.
and liberally, and you don't know whether what you're being told is true or not.
Right.
And you're running back and forth. But I think again, that everybody has, when you do ADR, you can provide your own rules. How much concern is there? It is cheaper to work out. They say it's not going to be more expensive if it was agreed upon. And if you agree upon, then the check of the work, the check to see involvement of AI and whatever can be whatever you want it to be. And the question in that kind of, for lack of a better way to describe it, negotiated resolution of a dispute, as opposed to a litigated resolution of the dispute, is it doesn't cost any more than what everybody agrees to pay.
Okay, it's a good way to look at it. So how would you, now arbitration is binding, right? So
right, it is if everybody agrees.
Well, let's pretend that you're now back in the courtroom. You're with Judge Yates there in the appellate courts, and this issue comes up. There's some evidence that came in, and was it really something that should have come in?
Well, it's interesting. Binding arbitration, as Judge Yates, I'm sure knows perhaps better than me, is very hard to reverse. There's been case law that basically says you can be completely, I mean, it does, I'm oversimplifying, but it says you, in a nutshell, it says you can be completely wrong as long as you're not corrupt. And if, now you don't want that, but that is the case law, which makes the rules that you devise, whether it's the American Arbitration Association, JAMS, or anyone else, very, very important. These providers have their own rules. You can modify them, but they're there. Right. And how expensive they are to implement in a given case is totally up to the parties and their counsel. So how do you minimize the cost? Minimize it whatever way you want to. But if you don't get a guarantee of the sufficient to satisfy your concerns, you got nobody to blame but yourself, because if you worked it out, right, then you paid for what you got, and you didn't pay for total security. You paid for 75% security. Depends on whether people suspect each other.
Well, I mean, you're already an adversarial relationship.
I come back as a judge, and I asked, as I said, in the climate change cases that I had that are being litigated all over the country, I asked them point blank to certify if they did in every memorandum that I got, on every motion that I got, and they did. And nobody said, no, I don't want to do that, or you can't make me, except the one guy said he knows of no authority for that. And I said, you do now. So that, but the answer to the cost factor is we're going to have to figure out what it ought to cost and work through it. And if it's not, it doesn't guarantee a perfect solution, maybe we don't want to pay for a perfect solution.
Final thoughts, guys?
This is another area where the law is going to have to evolve, I think. I wish it weren't so. I wish we could just leave it up to the jury, as we always have done, because it makes it much easier to be a trial judge. But it seems to me it's going to be incumbent upon trial judges to get informed and to be more proactive in dealing with allegations that documents are not authentic.
Right. Judge Platt, final thoughts?
Ditto.
Okay. With that, I want to thank you both for being here. Really appreciate your time, as always, and your insights. And with that, I think I'm going to kick this over to Mr. Kaplan.
Thank you, Cheryl.
Okay.
Thank you, Cheryl.
All right.
This is quite a challenge that we all have, that so many people in so many professions have relating to AI. You know, I've seen so much written about AI and the suggestion that we consider AI to be just another staff person in our office. We have an associate, a colleague in the office who's done a particular portion of the project. Certainly, we have an obligation to review what that staff person did. But now we have a staff person, the AI platform, that has got a history of having used hallucinogenic drugs, a staff person that has spent years and decades in the world of creative fiction. And what we're asking the staff person to do is do work, do research, gather together information, and formulate a compendium of it and do all of these particular tasks, which are not creative tasks, which in fact are founded by professional standards, professional methods, a professional industry. So we as experts, yes, we have to check that work. We have to check it and check it and check it because there's going to be more doubt and more skepticism and more things can go wrong. But no matter what happens, no matter how much checking we do, and if the AI platform has gone astray, the consequences are still there. And we as experts own the consequences, no matter what we've done.
Well, I think that's the key thing, Michael, is that we end up owning it. We don't have the ability to displace it.
That's right. So here is my thought about AI in our practices, because whenever I hear AI in the world of business valuation, I hear about using it for research, using it for doing analysis, using for gathering things, put the various elements and putting them together, use it for report writing. What if we think of AI as another type of tool, not the tool that develops the project, that develops our valuation report, our damages report, writes the report, and that's what we use as our tangible work product that we deliver to counsel or have counsel offer to be introduced as evidence. Why don't we think in terms of AI as a tool to challenge our work? Here's the valuation that I did, that I and my competent, capable, experienced, educated staff has done. This is the report. This is the underlying documentation. These were my decision points. These are the decisions I made. These are things that I considered and rejected. Bring all of that together and then ask the AI platform, ask HAL, or whichever platform we're using, what's wrong with it? What did I miss? Is there something else I should have considered?
Yeah.
What is opposing counsel going to ask his expert to do? What will the opposing expert, what will she do with all of the work that I did to come back with rebuttal?
This is so good, Michael. I know we could talk about it for a while. They're urging us to get to the last two segments, but I think that this is really an interesting perspective that is hugely important. And I think if we use it, like you're saying, to challenge us, to educate us, to equip us to be better prepared going into trial versus preparing the underlying data, this is an interesting place to bring AI in, I think.
It certainly is. And there's so much value there.
Yeah.
Instead of using it as a tool to automate the process and streamline the preparation process, use it as a tool to make our expert work that much better. to make us that much better.
You got it. All right, Michael. I think this is something that we will be doing more discussions on, because this is huge. We can't ignore it any longer. So I appreciate you being here, and I'm gonna roll to the next session with Janae Castell.
Great.
Awesome.
Thanks, Michael. Good stuff. Thanks, Mel.
You got it, Janae. I'm going to let you take it away and introduce your guest, and that way you can jump right into it. Thanks.
Great. So I have Pat Rafanelli with me, and real briefly, Pat is director at Empire Valuation Consultants. He's been doing this for a few years in valuation. Pat and I have served on a few different task forces and committees and boards and things together. And Pat is our incoming standards board chair. So he gets to take over from Greg and doing a lot of the work on our standards board. And if you all don't know that much about the standards board and what they do, hopefully what we talk about a little bit today can kind of help inform you, give you a little bit of information. We've got a few topics to highlight for you and hopefully give you something, some tools and some knowledge to utilize in your practice, and knowing a little bit about your membership and the NACVA, the association. So I want to cover less on the content of what was recently proposed by the IRS. Hopefully you're a little bit aware of the proposed regulations on who can practice before the IRS and what the standards are for those that do practice before the IRS. If you're interested in that, there was a fair amount written that you should be able to search for. However, things are pretty well on ice with this. So the point of bringing up this topic today is to discuss some things that go on in the background that you may or may not be aware of. What this means for you, and hopefully you knowing a little bit more about the process and the inner workings can help in the future when these kinds of issues come up. Oh, excuse me. Go back there. Perhaps you'll know where to look for information on responses of an organization or of the organization you're a member of. And if you're ever wanting to put together responses as an individual, this may be something to help you with. So perhaps, maybe though, this is something that you want to get involved in. If this sounds like something that's interesting and you want to be involved when things like this do come up with the Department of Labor or the IRS, maybe this is an area where you want to become involved. So what happened was December, the IRS, late December, the IRS put forth proposed regulations on the Federal Register. You may have seen chatter on LinkedIn if you're connected in the valuation community. The NACVA in January put together a task force of standards board members, the EAB, and the Leadership Initiatives Board, as well as Peter Agripides as an appointed member. So the deadline, so between December 26th to February 24th, to put forth public comments, was kind of a tight deadline, but the NACVA did that real quick, and Michael pulled together these individuals. They worked on a response to represent the association, published that. You may have seen some emails come through on guidance and what was happening, and if you wanted to put forth your own individual response. So these are things that were done and things that will continue to be done in the future. The NACVA then sent members to testify on behalf of the association and its membership and credential holders. The AICPA and the ISBA also each sent one member to testify. The ASA was not there. The responses from the NACVA highlighted, the role in developing harmonized valuation standards, training IRS professionals, creating comparison charts to guide analysts and users of BV through differences among the various standards. Emphasize that we're already bound by existing standards and talking about, governance of ourselves rather than having IRS agents that may not really be as well versed and be bound by the same things that we're bound. So this is what was put forth. And this also highlights some other tools that you have and some things. Oh my goodness. Okay. So some other tools and some other options that you have to avail yourself to. I've lost my PowerPoint, but the next thing, as I bring that up, is the advisory briefs. So you may have seen an advisory brief notification come through. Pat, I'm going to pass that over to you as I get that loaded back up so that we have links and things if anybody wants to check out where that is.
Excellent. Thank you, Janae. So the advisory briefs are briefs that are non-authoritative guidance that the association puts out for our members. We currently have one brief up there. It was from October 2024. The Artificial Intelligence and Machine Learning Commission issued it. The brief is about 2 pages long, and it covers 5 main sections. The principles to be used in valuation practices, which pretty much, dictates that it's not to replace our expertise, professional judgment, which pretty much means that we still have to use our capacity as analysts, as experts, our experience, our education, our training, and our skills. It goes into ethical considerations that we have to consider, verification and reporting. We need to make sure that the outputs are not misleading, and then that we need to continue to learn and adapt using that information within the methodologies and the valuation procedures. So, like I said, that brief is about 2 pages long. And it goes through some more depth and detail about those 5 sections, as well as providing some examples as to what we're trying to convey over here. And that link is over here on this slide. So is there anything, Janae, that you want to add to that?
No, just that this was the first of the advisory briefs, but there's anticipated that as issues come up, that there may be the need for future advisory briefs to be issued. So if this is something that you have an item or an area of concern that you would like additional information, you submit a request via email, and your request will go to their appropriate board or the appropriate governing body. And then there may be future advisory briefs come out on different topics. So something to keep your eye on, something to be aware of as a resource for you. So the next tool that we have, Pat, is the resource toolkit. And there's a lot coming up on this for members, but why don't you talk about the engagement letters that are now available?
Yep. So on this page, and this is a member-only page, so you only have access to this once you log in. But the Standards Board spent a good portion of last year coming up with 4 sample engagement letters. The engagement letters cover calculation engagements, litigation engagements, review engagements, and valuation engagements. These letters are meant to act as samples and provide guidance for our members as they're preparing their letters. And they cover some topics, including but not limited to premises of value, firm representation, client responsibilities, reporting results, professional fees and retainers, billing, arbitration provisions, good faith opinions, electronic data communication, storage and third-party providers, termination, acceptance. And within these topics, there's not only language that should be considered to be used, but also different scenarios and different options. We wanted to try to make these letters as all encompassing as possible. So, for example, when you're looking at the standard of value section, we have narrative for fair market value, for fair value in litigation, for fair value in financial reporting. Under the client acceptance, as another example, we have language if you're being engaged solely by the attorney, solely by the client, or if this is a mutual engagement where both parties are retaining you. Each document is about 6 pages long, and where it is optional, whether it's one of those, you pick one option, or it's just an optional clause, we actually specify that it is optional. So again, these letters were to try to provide guidance to the members. They're trying to capture as many areas as possible for you to use, but you do need to keep in mind that all the work that we do is unique to the job, to the client. So these letters do need to be tailored and sometimes may need additional topics that we just haven't picked up or haven't covered. Is there anything you want to add to that, Janae? And I know I went through that quickly because I know we're up against
Yeah.
time, so I apologize.
Yeah. No, I think, having an awareness, everybody, of what's there is really, I think, the main point. Here's what we're working on. Here's some of the materials and things that the standards board, the evaluation credentialing board, the ethics board, all these boards they're working on to put out. So knowing that these are there, I think, is really important, just that you have that available for your practice. The menu, the customization on the engagement letters, you're not going to use each of these pieces in each engagement letter, but you have that some language to kind of get you started in a number of different scenarios. And just I would add to make sure that you're always having your own legal counsel review your engagement letters and looking at your documentation. This is a starting point, and an effort to kind of give you something to go with, so you're not starting from scratch. But definitely use these, in develop these in concert with legal advice of your own. Don't take this as legal advice from the association, right? Okay, so I've got just a list. Here are some links of the items that we talked about today. So the standards, the nacb.com/standards, is going to give you our standards and what's there. You've got the different comparison charts. There's a lot there, and there are a lot of things that are actually going to be forthcoming and that will be discussed in future editions of Around the Valuation World. But here's a few things to get you started, and keep your eye on those because there's always things going on in the background that will become available to membership. All right, Alina, we'll let it go back to you and get Stephen out here. I know he's anxiously waiting for his time to come up.
Yes, I can imagine. Thank you, Janae and Pat, and thank you for just crunching your presentation so we have time for Stephen, and I'm pretty sure he is waiting for this. So now we are going to have Stephen. He's going to be interviewing Adam Sher, and they are going to be talking about adding transfer pricing reports to your practice. And I'm one of those that thinks that our skills is perfect for doing compliance work about transfer pricing. So I'm interested in hearing about this. So Stephen.
All right. Good afternoon, everyone. Adam, are you there?
Yeah, hello.
All right. All right. Well, we are the final leg of this beautiful, exciting day of great information here, and I can't think of a better topic to talk about than transfer pricing. But before we dive into that, let me just let everyone know who's not familiar with Adam. He has performed assets and business valuations throughout his entire career. The types of valuation work that he's worked on fall into 5 different categories. He's done real estate, real assets, technology companies, marketing companies, as well as franchise retail companies. So we are pleased to have Adam here be a part of this show. And the topic of our discussion is introduction to transfer pricing. And when Adam and I first started discussing this topic, I told him, I said, we do M&A valuation, and of course, transfer pricing comes up in discussion. But it's not something that is really talked a great deal about here in NACPA. So it sounds like it'd be a great topic for us to dive into. So Adam, I'm going to turn it over to you. Why don't you start us off by telling us a little bit about transfer pricing, and then maybe go into why you think this will be a great opportunity for us in the association.
Sure. So transfer pricing is a requirement by the IRS that's applicable to all U.S. companies, and it comes into play when there's 2 related businesses that share a service or charge back a service. And this often comes up where you might have a company that has IP as a significant part of its value or business proposition and wants to further isolate the IP from risk. So the business owners create a new co for the IP, and they license the IP to the operating co, and then they charge a fee. There's also companies that might open a U.S. office for purposes of insurance and listing contracts with U.S. customers in the U.S., or vice versa, a U.S. company that's opening a branch overseas, whether it's for cost to service customers over there or to take advantage of lower wages. And so they're charging themselves or a related entity, if it's not wholly owned, for the services. And so the IRS is really keen on this because the most obvious thing that comes up is, well, you could just move a lot of your business to a low tax jurisdiction, charge a big rate out of the high tax entity, and then not pay a lot of taxes. And so, you see this come up locally, where people want to move to Texas or Florida for personal taxes, and people do this for businesses in Puerto Rico.
Right.
And the way I think this, is a direct, part of valuation is the methods to evaluate in transfer pricing are different language, but the same versions of like a market method, basically.
Right. No, I agree with you. I agree with you wholeheartedly because when I look at transfer pricing and evaluation, I think they're very similar. Well, they're closely related. Let's look at it that way because you are involving determining the value of the goods and services or the intangibles that are within the overall company itself. It's just that transfer pricing is more specifically focuses on the pricing of those particular transactions that are ensuring that they're kind of aligned with the arm's length of that overall transaction. At least that's how we see it from an M&A perspective.
Yeah. And I think the principle of an arm's length transaction is similar to, a third party financial buyer, if you're looking at fair market value in a conclusion of value engagement. So I think the terms are a little bit different, but the concept is almost exactly the same. And so it seems like a good branch to go into or a service to offer.
Right.
It's also something that, then companies subject to transfer pricing, it's an annual engagement. So it's recurring work, which is nice. And if the companies are successful, they tend to have more of the issues that you sort of get a greater scope. So all good things.
So let's talk about the kind of like the valuation market methods and the comparisons, as I mentioned, how they are similar or closely related to one another. Why don't you walk through from a valuator perspective? We are familiar with the valuation market. How do they combine or translate over as far as the market method, which you touched on just briefly?
Yeah. So in transfer pricing, there's a handful of methods you look to specify the IRC to evaluate like if something's an arm's length transaction. So, and I'll use a couple of examples. So I won't go through all of them, but I'll use some real life examples. So
okay.
And this is where like the definitions add more to confusion than they do clarify. So if you look at like comparable uncontrolled service price, that's where you're looking at what other companies would pay for the same service. And this is a common method used in valuing intangible assets. So in the example of a company has IP that they've isolated in a different company, and they've licensed the use of that technology back. Now, specifically, a client had fundraised, and so the operating company was a corporation, and it was a very profitable business, and they held the IP in a partnership for taxation purposes, and so a couple of benefits there, and then they charged a very high proprietary license for the IP. And so obviously there's a tax arbitrage and they've got some IP. So this is the type of thing the IRS looks at. And so in this market method, you have to look at other IP agreements exercised, by independent third parties, basically at an arm's length. And so similar to you might use, a BizComps database. In this case, you're looking at like KT Mine is a popular database for royalty agreements and license agreements to try to find what might be either comparable or if not comparable or guideline transactions. And so similarly, You have the same types of challenges you do in these agreements because not every company is the same. The size of the agreements are different. The terms are different. So you end up applying your judgment to how similar are the companies. Is it even in the same? Are they even in the same industry? Or is there enough transactions in your data set to even do the analysis, or do you have to look for another method? So in this case, we were able to go from a high 1,400 potential royalties agreements down to basically what ended up being is 6, where you had close similarities in term. The percent wasn't necessarily the same, but the exclusivity, business size, and term were the same in the market, in the industry were similar, so you could apply it. So it's the same process you're doing. And yeah, that's a good question. Can AI be used to go through the agreements? And I would say I haven't seen a great use of that. So some of the case law databases have AI in them, and I think it goes back to the earlier conversation.
Right.
My trust in it isn't all the way there. So it's one of those things where if you kind of know the answer ahead of time, it can help you speed up your search. So in this case, we thought something between like 25 and 35% is market, which is something, based on experience you see. And so we could filter using that, because these agreements could be 5 pages long. The agreements could be 100 pages long, the royalty agreements. And so it can help you parse the information. In terms of a checklist, I haven't had a lot of success on getting that level of sort of AI implementation.
So, Adam, there's a couple of other questions here, because we did talk about revenue streams. For this particular type of work, is there like a small fee that you've been seeing, or do you have any other suggestions for it being more of an efficient process?
I guess it depends what you think is a big fee or a small fee, but some of the fees we've charged for a company that's setting up a new operating company, and is using like labor. I mean, the complication is how complicated the business is and how many transactions are shared. Is a big determinant. But if you're a small business who has wages you're passing through because you have an offshore sales team, that might cost $7,500 for year 1. And then years 2 and 3, you can, you're allowed to keep your process the same and update your financial information, so a slightly lower cost. And then on year 4, you restart with an original analysis. Then for more complicated businesses or harder to find information, it could be $15,000, $20,000. And then for high revenue businesses that have a lot of shared services, in the hundreds of millions of dollars, it becomes potentially useful to have basically an advanced agreement with the IRS. And the average cost of that is well over $100,000. And so that's for very few companies and clients. And it takes several years to get something like that in place, per the IRS stats. So yeah.
Well, I appreciate this, and I know that we're right at the top of the hour here.
Sure.
I know we could go on for much longer time here talking about this, but on the screen you have some links here for the audience can go into, do a little bit more research in this, and I would love to reach out and see if Elena, we can bring you back on again to really have a deeper dive into transfer pricing and how this can be a new revenue stream for everyone.
Yeah, that would be great to work on.
Yeah, I agree. This is a great area. You mentioned Puerto Rico, so we have a lot of those in here, especially with business valuations,
Yeah.
transferring the value of the business here, or even services. That's the area that we work a lot. So I think definitely is an area that business valuators can expand on because we have the skills to work on that. So appreciate you being here with us. Thank you, Stephen.
You're
And for all
welcome. Thank you, Adam.
Yeah, thank you.
So for everyone, just make sure that if you want to subscribe to the AI conferences, go to the link that we provided you. And also in September, remember our annual conference is not going to be December, it's going to be September. So make sure you register and we'll see you next month. It's going to be June 23rd. So Father's Day is before that. So congrats to every one of you. Bye, Mel. Bye, everyone. See you next month.